Welcome to the continuation of Freedom Watch's Citizens Grand Juries. You can see prior versions, prior meetings, prior convenings, for lack of a better word, of our Citizens Grand Jury at freedomwatchusa.org. The authority for Citizens Grand Jury stems from a case decided in 1992 Supreme Court majority opinion written by the late Justice Antonin Scalia, where he, writing on behalf of the entire court, ruled that the grand jury belongs to the American people, not the three branches of government. By extension, once you can indict, the people have a right to try. They have a right to seek convictions, and they have a right to sentence, and they have a right to carry out those sentences. In fact, in 48 states in this country, as a matter of law, a citizen who knows of a felony that's been committed has the right to arrest the person who committed the felony. Now, most recently, we had scheduled a trial of Joe Biden, Hunter Biden, and James Biden, as well as Anthony Fauci, with regard to the Bidens for alleged bribery from communist China, from Russia, not coincidentally, and Ukraine before President Zelensky took power in the Ukraine. Very corrupt government before he took power. Still cleaning up the corruption, but obviously he's been diverted with the Holocaust, which is going on right now, caused by Vladimir Putin of Russia. We are also going to try Biden for treason, for selling out the United States and Afghanistan, and for killing 10 innocent Afghan allies. When 13 GIs were killed at Kabul airport to look tough, Biden ordered a drone strike, not knowing who he was striking. He struck our allies and killed 7 young children. We have had to postpone that because you can see my voice is impaired. I've been ill for the last week. So has my assistant. He's in better shape than I am. You'll see him. But the case of the trial of the Bidens and of Fauci, who is alleged through a grand jury indictment to have lied to Congress and to collaborated with the communist Chinese, giving us COVID-19. That's being reset for June, the week of June 13th, and we will be trying them at that time. Now, as far as what's going on today, we're seeking the indictment of Josh Gerstein, the Politico reporter, who is alleged to have collaborated with someone inside the Supreme Court, perhaps a law clerk, maybe even of the recent Supreme Court justice who's yet to be seated, Ketanji Brown Jackson. We don't know that for a fact, but we do know that Gerstein was implicated and is involved in the theft of government property. Reporters, investigative journalists like Gerstein, a member of the ultra-left, a member of the Marxian Jewish left. You know, I'm a Jewish Christian, so no one can accuse me of being anti-Semitic, but the Jewish left is a very destructive force in this country. Frankly, they're destructive of other Jews. They're destructive of Israel. Examples of who comprises the Jewish left are George Soros and Bernie Sanders, who are not really Jews at all. But I don't want to dwell on that. But I just want to give you a little background on Gerstein, because he is part of that establishment, that Jewish leftist establishment. He did play a role, we believe, and we're presenting the evidence and seeking an indictment. And indictments can be obtained even on mere suspicion, as Justice Scalia wrote, but there's more than suspicion here with regard to Josh Gerstein. Clearly, he probably received this from a clerk. He induced the theft of property. This is a big moment in his career. He became big man on campus for the left, which is pushing, of course, so-called abortion rights. Of course, abortion rights are not rights at all. There's no right to kill unborn babies. That's a misnomer. That's as much of a misnomer as being a progressive is if you're a leftist. It's more like being a regressive. But we are seeking the indictment because we need to hold journalists accountable just like the rest of society. And what he has done for political purposes to try to influence elections later this year and in 2024, as well as to create violence, to sow violence and mayhem and destruction, is frankly more than reprehensible. It's a felony. So we're going to be presenting evidence today. We will ask you to indict Josh Gerstein. We need to set an example that as reporters can do these kinds of things. They're no different than the rest of Americans. They need to be held accountable under the rule of law. I've had my own issues with Josh Gerstein, a defamation case pending against him in Florida. He's tried his best, along with Politico, a very leftist publication, to harm conservative legal advocates and others. He's a radical leftist who, frankly, is in favor of pushing the Biden-Harris regime's agenda and sowing discontent and hatred, now among the sexes, previously among the races and others. And people like this need to be held legally accountable. Once we get the indictment, we will then put him on notice of it for his arraignment. He can plead innocent, not guilty or no loc contendere, and he will be tried. And he will be tried during that period of June 13th, the week of June 13th, if we get an indictment from the citizens grand jury who are present here today. Now, I'm going to turn it over to my executive assistant, Asher Anderson. He's going to show a videotape of a little background of what's occurred with regard to releasing this this decision from the Supreme Court, this draft decision, which would overturn Roe v. Wade, the abortion decision. A little side note, when I was in law school, one of my classmates was Sally Blackman. She was the daughter, she is the daughter, she's still alive, Harry Blackman is not, of the Supreme Court justice who wrote the opinion, Roe v. Wade. Interestingly enough as well, Harry Blackman was an appointee of Richard Nixon. He was not appointed by a Democrat president. It shows you how things have changed over the years. But I remember in my constitutional law class, and things were not as severe as they are today. I was at Emory Law School in Atlanta. Some people would say, the professor, that there's a woman's right to choose. And I would get up and I'd say, look, there's no woman's right to choose. There's no right to choose death. And a man has a say in what goes on too, with regard to a child. This is just a little background. And this is the controversy that exists today, a very violent controversy between the sexes and between left and right and others. But as far as what happened with Gerstein, you can even take all the politics out of it. You can take it completely out of it, members of the citizens grand jury. This was the theft of government property, property belongs to people of the United States, a draft majority opinion, which he then participated in taking for his own political purposes and the political purposes of his publication, Politico, a leftist publication, and the left in this country. So, Mr. Anderson, I'm going to turn it over to you right now. Your voice is in better shape than mine, but I didn't want to delay on this because this issue has not been reached. It has not been even discussed, the role that Josh Gerstein played in committing an alleged crime. Take it away, Asher Anderson.
Right now, just breaking in the last few minutes, is this. The United States Supreme Court has voted to overturn abortion rights, draft opinion shows. According to an initial draft majority opinion written by Justice Samuel Alito, circulated inside the court and obtained by Politico, the Supreme Court has voted to strike down the landmark Roe versus Wade decision. The draft opinion is a full-throated, unflinching repudiation of the 1973 decision, which guaranteed federal constitutional protections of abortion rights, and also a subsequent 1992 decision, Planned Parenthood v. Casey, which largely maintained the right. Alito writes in this draft majority opinion, quote, Roe was egregiously wrong from the start. We hold that Roe and Casey must be overturned. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives, which, as Chris was just mentioning there, means returning it to the states. And in more than 24 states, there are what are called trigger laws, which would immediately render abortion a crime, render it illegal, immediately upon the Supreme Court issuing such a ruling. As Josh Gerstein reports, along with his colleague Alexander Ward at Politico tonight, quote, the immediate impact of the ruling would be to end a half-century guarantee of federal constitutional protection of abortion rights. It would allow each state to decide whether to restrict or ban abortion. It is unclear if there have been subsequent changes to the draft. This draft ruling that has been obtained and published by Politico tonight was reportedly drafted in February. Politico received a copy of the draft opinion, quote, from a person familiar with the court's proceedings in the Mississippi case, the abortion case, along with other details supporting the authenticity of the document. The draft opinion runs 98 pages. The document is replete with citations to previous court decisions, books, and authorities, and includes 118 footnotes. The appearances and timing of this draft are consistent with court practice. The disclosure of Alito's draft majority opinion is a rare breach of Supreme Court secrecy and tradition around its deliberations. Joining us now is Josh Gerstein. He's the senior legal affairs reporter for Politico. He's one of the best legal reporters and legal political explainers in the country. He broke this story tonight along with his colleague Alexander Ward. Josh, thank you for coming on tonight on such short notice. I realized that you didn't know 4 minutes ago that you were going to be on TV talking about this with me tonight.
No problem, Rachel. Happy to join you.
I'm not going to press you, of course, on your sourcing here, but I want to press you on your confidence in your sourcing. Obviously, this is a very unusual, if not completely historically unprecedented leak, a document that purports to be the draft majority opinion of the Supreme Court before they have issued any such ruling. Can you just tell us about your confidence in the authenticity of the document?
Well, we're very confident in the authenticity of this draft majority opinion, Rachel, both in the way that we obtained it and other information that we got that supports its authenticity and makes us believe that it is genuine. Now, of course, it's not a final opinion. It's a draft opinion. It was circulated in the court as a first draft by Justice Alito in February, dated February 10th. So it is possible there have been some changes since then, but it's our best understanding of at least where the court stood at that time, which is about 2.5 months after arguments in this pivotal Mississippi abortion case. And
you report, Josh, and again, forgive me if I get any of these details wrong. I am learning this as I'm talking about it, which is always dangerous. But you report that the court majority here is established, that there are, at least in the initial conference between the justices after the arguments, there were 5 votes on Justice Alito's reported side here. And the only ambiguity, the only question is whether or not Justice Roberts would make it a 6-3 decision or a 5-4 decision if he chose to side with the more liberal members of the court. Do you have any, what can you tell us about your reporting in terms of the numbers here, in terms of how the two sides align and whether that may still be a matter with some fluidity?
Well, it's our understanding from a person familiar with the proceedings that Justice Alito believes and that the court has 5 justices that are essentially aligned with this opinion that he's written, which is, just a withering takedown of the Roe v. Wade precedent. It pulls no punches at all. It's pretty brutal. And in the way it's structured, it kind of needs to be that way because of the way Alito confronts this issue of court precedent. Stare decisis is the legal term, and something has to be really, really wrong if they want to overturn it. And that's the case that Justice Alito makes here. There is still some ambiguity about where Chief Justice John Roberts stands, as many people noted at the oral arguments at the beginning of December. It sounded like he was finding a way maybe to approve this Mississippi law, which is a 15-week abortion ban, without completely ripping down the Roe v. Wade precedent. Our understanding is that, most of his Republican colleagues want to go ahead and take down Roe versus Wade. Now, that said, we're at the beginning of May here, and this final decision likely won't be published until the end of June, perhaps even the beginning of July. So it's fair to say that this, is a situation that is unresolved at this point, and I can't promise you that various things may not change between now and late June.
Josh, in terms of the substance of this opinion as written, again, this draft majority opinion, and with the caveat that this is a historically unprecedented leak of what appears to be a draft majority opinion from the court before any ruling is issued, with the caveat that you just described in terms of whether or not this may go through additional changes, even potentially substantial changes, before we see the ruling from the court as published later this year. With all those caveats intact, when you look at what Justice Alito wrote here, how does this comport with expectations in this case? Obviously, as you were just describing, the leanings of the justices on this matter, I think to realist-minded observers were clear even before oral arguments, and certainly were clear thereafter. But I think it was also perhaps still common wisdom that the justices would try to soft pedal this a little bit, that they would try to undermine Roe and effectively remove the protections of Roe without a sort of 21-gun salute. Which is what this appears to be, at least in terms of the way that you've been able to describe Justice Alito's thinking. Is that a fair assessment of this, that this is more of a bludgeon when it was perhaps expected to be something more of a more subtle approach?
It's definitely a swing for the fences draft majority opinion. He's really holding nothing back here, Justice Alito. And, you know, I know what the conventional wisdom was, Rachel, that maybe the court would try to soften the blow. But at those arguments, there was precious little indication of that from any of the Republican appointed justices other really than Chief Justice Roberts. And another reason to think that this may have full support from all the Republican appointed justices except the chief is if you go through the opinion, you'll find echoes in there of views that other members of the court have stated on previous occasions. There are parts of this opinion that sound a lot like Justice Clarence Thomas. When you read through it, you'll see on a few occasions the word abortionist appears in this opinion. That's a word that Justice Thomas has taken to using in recent years and that most of the other members of the court don't typically use. And there's another passage that seems to cater to some comments that Justice Amy Coney Barrett made at the oral arguments about the way views on sort of unwed pregnancy, out of wedlock births, and women's rights have evolved since the Roe v. Wade was handed down in 1973. So it really does seem that Alito is trying to cobble together a majority. People can also look at it and see how much do you think it does to address the concerns Chief Justice Roberts has raised about the credibility of the court and the concern about public opinion. I think there's portions in it that don't seem to give full weight to the chief's concerns, which also supports the notion that maybe he's not expecting to be part of this opinion.
Josh, in terms of the likely impact of a ruling, if it does in its final form look like what you have reported and published tonight, if we had a Republican-controlled House and a Republican-controlled Senate and a Republican in the White House, is there any line in this ruling, as you read it, that would prevent the legislature and the president from establishing a new law that full-on banned abortion in its entirety in every state in the country in every instance?
Well, it's a draft decision, and it doesn't really get into the issue of what the federal government's power, I think, would be in this area. So I think it certainly leaves that open as a possibility. There might be other obstacles to that, like the legislative filibuster we still have, at least for the time being, in the United States Senate. But, you know, there are points at which Alito tries to suggest that, you know, this won't bring all the scenery down. If we move away from abortion to other privacy-based rights, such as contraception, rights like gay marriage, he does try to ring-fence this opinion and say, all we're talking about is abortion. He mentions that several times, and he suggests that it shouldn't be stretched into other areas. That said, I'm old enough to know that the court many times has said, don't try to apply our opinion on X to this situation Y because it's different, and yet it often does get applied that way. But there's no question he's trying to keep this confined to the issue of abortion.
And of course, that's telling in itself, right? To be willing to say, like, oh, this is just about abortion. It's not about anything important. Don't worry. Tells you a lot about the frame of mind of the frame of mind behind people who would make this kind of a change. Let me just ask you about one last piece of this, Josh. Since we've been on the air, since we received your reporting tonight, since you published, we, on my show, have contacted 4 former clerks for Supreme Court justices, all of whom uniformly told us that the document that you have published tonight appears to be a legitimate work product of the court, meaning it just matches in form and style and texture the kind of product that they, as clerks, were used to seeing as a draft majority opinion. That highlights in itself, I think, the unique nature of this reporting that you have done and this leak. And I wonder if you have any reflection on what it might mean for the credibility of the court, for the legitimacy of the court, for a draft majority opinion to have made its way into your hands. This is something that has never happened before in the history of the court. And as a court observer and somebody who understands how the court fits into our politics, what sort of impact do you think this will have on the court itself?
Well, I mean, there have been leaks out of the court before, perhaps not of this magnitude, but we've all gotten kind of used to, on these big decisions, such as Obamacare, such as this abortion decision, to hints, body English, I might call it. There's a nuanced reading of editorials that appear in different places, places like the Wall Street Journal editorial page, where you can often see indications that maybe the court is moving one way and conservatives aren't happy about it. You do see that kind of dialogue, but never accompanied by an actual opinion. So I do think that this is groundbreaking, and it does take the court into new territory. It would certainly be very interesting to know what Chief Justice John Roberts thinks about this, even if he doesn't agree with this opinion. What does he think about whether this causes the court to be viewed as a political institution by some people? That's what we're going to have to see how it plays out over the next couple of months as this continues to resonate towards the final decision at the end of June.
Right. And the importance of Chief Justice Roberts' opinion on matters like that is not just, what he thinks as a person and how it affects him personally. It's that the court is effectively a self-regulating body that sets its own ethics and standards. If this is going to sort of shake the foundations of the court and its perception and its role in politics, his opinion will be more important than anybody else's by a considerable margin. Josh Gerstein, senior legal affairs reporter for Politico, you will always, in your entire life, be the reporter who broke this story, whatever else happens in your life and everything else that you've done in the past. I know this is a really big deal, and I really appreciate you being here tonight with us. Thank you.
Thanks so much, Rachel. Take care.
All right. I will just mention, let me just restate what it is that we're talking about
Anderson,
here.
go ahead, and that what you, the grand jurors, has just seen, not just the grand jurors who are present on this session, but the grand jurors who will also review the video of this, which will be reviewable. So there are more than grand jurors involved and just are currently watching, because this is our process. We use Zoom, we use a video, and we let people convene and discuss matters and determine what to do. But I am the citizen's prosecutor, and I'm talking to you in that vein. It's clear that this is the highlight of Josh Gerstein's leftist career, that he intended to do exactly what he did. It's clear that he had intimate involvement with the person who provided this to him. It's clear that he played a role in providing the draft opinion of Samuel Alito. He knows the deliberations of the court. He knows how the judges are going to vote. He knows a lot of other information that was provided to him. He is as guilty of stealing government property. And again, it doesn't have to be even of a certain value. It can just be information, as we set forth in the indictment, as the person who actually provided it. And like I said, there is also reasonable suspicion that he knows the person who did this and perhaps even attended his or her wedding. So this is something that's going to be investigated, but there's enough right now to get an indictment. It's clear what his motivations were. It's clear that he's now the darling of the left. It's clear that he intended to create a reaction, not just in terms of people's voting ability and desires coming in future elections, whether it's the midterm elections or the presidential election of 2024 and beyond. But one has to also assume that he intended to create social upheaval, if not violence. And this is what the left has been doing, particularly in the last year and a half, since Biden and Harris assumed the White House and assumed control. So this is extremely serious. Josh Gerstein has just indicted himself. It's clear from his statements. He understands the ramifications. He was willing to take the risk. But there is no risk in terms of our so-called government. They will not prosecute him. The Justice Department is controlled by the Biden-Harris regime. And even if it was controlled by Republicans, there would be no indictment because they're worried about the blowback on them. And they're worried about that the situation could be flipped next time that they do something just like Gerstein and this leaker did. The Supreme Court, in my opinion, quite apart from what happened here, it's not a question of damaging its reputation. It's already been damaged seriously. You can see from the way voting occurs that it occurs almost 100% along the lines of which president appointed which justice to the Supreme Court. That is not the basis of our legal system, which is supposed to be neutral. The Supreme Court is a political body. It is not representative of the American people. And in fact, it was Thomas Jefferson who said, and he was against Article 3 judges, which include Supreme Court justices, unelected, unaccountable to the people, they would become despots and tyrants, causing us to shed the blood of patriots and tyrants yet again every 20 years or so. He didn't want to see violence, neither do I, neither do you, neither do any of the grand jurors. But it tells you that what we're going through right now is a highly politicized time. But there's something that is beyond politics, and that is taking the life of an unborn baby. Hundreds of millions have been slaughtered in abortion mills for decades. If you believe in God, you cannot believe that God's sitting by idly saying, okay, no problem, do as you wish. A woman's right to choose. Woman has no right to choose death, nor does a man have a right to choose death. And consequently, these are very, very grave times and grave circumstances. And to make matters worse, while the Supreme Court is a political body, Gerstein has just manipulated it for his own private and institutional leftist purposes, and he must be held accountable under the rule of law. So we will be presenting this to the citizens' grand jurors. There are some typographical errors in this. This was a draft indictment. We'll present it in a very clean form, and we will ask for an indictment, and we will seek to try him, not just under the laws of man, which we set forth in this draft indictment, but the laws of nature and nature's God, as it sets forth in our Declaration of Independence. That is higher than the law of man. And to kill an unborn baby is beyond anything that man-made law can even address. God will ultimately be the provider of justice here. But in the meantime, while we're all still on earth, it is time for us to enforce the law.
So this is the criminal indictment, the proposed indictment of Josh Gerstein, the people of the United States of America versus Josh Gerstein. The general allegations are as follows. The focus of this particular citizens grand jury indictment is on the theft of and concerted action by Josh Gerstein to steal U.S. federal government property or U.S. government federal property and the resulting threat and danger of serious bodily injury and or deaths of the U.S. citizens, U.S. Supreme Court justices, and or their families by the publication of a draft opinion of the United States Supreme Court in the pending and undecided case of Thomas E. Dobbs, State Health Officer of the Mississippi Department of Health et al. Versus Jackson Women's Health Organization et al. Record number 191392. Josh Gerstein is the senior legal affairs reporter at Politico. Politico is a newspaper focused on events, development, and news from and about the U.S. Congress, the federal government, and the political world in the United States of America, or news affecting those segments of U.S. society. Politico is currently published online on the internet as an informational website or news magazine website. Politico is a publication of Politico LLC. On or about May 2nd, 2022, Josh Gerstein with Alexander Ward published a news article which included and was written about and around a first draft of the purported decisional opinion of the U.S. Supreme Court written by Justice Samuel Alito. See, Josh Gerstein and Alexander Ward Supreme Court has voted to overturn abortion rights draft opinion shows Politico, May 2nd, 2022, updated May 3rd of 2022. And I will go ahead and share this with us so the jury can see. So this is what they were, what we are referring to here in the indictment. And I'll read a bit of this and then I'll move back to the indictment. The heading is going to be Supreme Court has voted to overturn abortion rights, the draft opinion shows. This is the article first put out by Gerstein himself. It says, the Supreme Court has voted to strike down the landmark Roe v. Wade decision according to an initial draft majority opinion written by Justice Samuel Alito, circulated inside the court and obtained by Politico. The draft opinion is a full-throated, unflinching repudiation of the 1973 decision, which guaranteed federal constitutional protections of abortion rights, and a subsequent 1992 decision, Planned Parenthood versus Casey, that largely maintained the right. Roe was egregiously wrong from the start, Alito writes. We hold that Roe and Casey must be overruled. He writes in the document labeled as the opinion of the court, it is time to heed the Constitution and return the issue of abortion to the people's elected representatives. And then here, and I'll share this article with everybody. This will be the draft. Within this article, it'll have the draft of the Supreme Court of the U.S. The opinion. Deliberations on controversial cases have in the past been fluid. Justices can and sometimes do change their votes as draft opinions circulate, and major decisions can be subject to multiple drafts and vote trading, sometimes until just days before the decision is unveiled. The court's holding will not be final until it is published, likely in the next 2 months. The immediate impact of the ruling as drafted in February would be to end a half-century guarantee of federal constitutional protection of abortion rights and allow each state to decide whether to restrict or ban abortion. It's unclear if there have been subsequent changes to the draft. No draft decision in modern history of the court has been disclosed publicly while a case was still pending. The unprecedented revelation is bound to intensify the debate over what was already the most controversial case on the docket this term.
I think that's enough of an introduction, Mr. Anderson, as that, you now see Gerstein's involvement in this. He obviously played a role in obtaining it from the Supreme Court. This is unprecedented. He obviously had to know somebody inside the Supreme Court. There are rumors out there that a clerk to Stephen Breyer, who's retiring, the newest justice to come on the court, Ketanji Brown Jackson, will probably inherit one or more of those clerks, that Gerstein went to a wedding of this person. We don't know that for a fact, but that's the rumor that's out there. But in any event, we do know that somehow it wound up in his hands, which is enough reasonable suspicion of probable cause to seek an indictment for misappropriating government property, in this case, to cause political mayhem, even physical attacks on Supreme Court justices and people who believe in life. So continue to read the indictment, Mr. Anderson. I think this will be sufficient.
Interestingly, upon the publication of Josh Gerstein article, before anyone had read it yet, Politico published the article with a photograph of past demonstrations outside the U.S. Supreme Court at the top of the article. Thus, Josh Gerstein knew and intended that his theft and publication of the draft U.S. Supreme Court opinion would spark political outrage and demonstrations, if not mayhem, assault, and battery, in the U.S. Supreme Court by supporters of abortion. The Politico article provided by an internet hyperlink the complete text of the document. The document stolen and published by Josh Gerstein includes the notation at the top, first draft, and is dated for February 2022 in the caption. The document stolen and published by Josh Gerstein declares that it is written by Justice Samuel Alito as presenting the opinion of the U.S. Supreme Court. The document stolen and published by Josh Gerstein included a routing stamp circulating the draft opinion to the other U.S. Supreme Court justices, bearing the circulation date of February 10th, 2022. The document posted by Politico included Josh Gerstein's notations by highlighting the certain portions of the draft opinion with a box and dull yellow background color. The document posted and widely disseminated by Politico did not include any dissenting opinions or concurring opinions from the U.S. Supreme Court justices, nor customary references in the body of the main opinion to the analysis of dissenting opinions. Thus, the document indicates that it is not the final or formal opinion of the U.S. Supreme Court, which includes a formal package of all of the dissenting and concurring opinions of various justices, and in the majority opinion typically refers to and discusses points raised by the dissenting opinions. In the article, Josh Gerstein demonstrated his awareness and intention for the impact of his actions by writing with his co-author. No draft decision in the modern history of the court has been disclosed publicly while a case was still pending. The unprecedented revelation is bound to intensify the debate over what is already the most controversial case on this docket, or on the docket this term. And Josh Gerstein further explained and revealed that his acquisition of the draft opinion was accompanied by his discussions with the source of the document, not merely acquisition of the document itself. A person familiar with the court's deliberations said that 4 of the other Republican appointed justices, Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, had voted with Alito in the conference held among the justices after hearing oral arguments in December, and that lineup remains unchanged as of this week. The 3 Democratic appointed justices, Stephen Breyer, Sonia Sotomayor, and Elena Kagan, are working on 1 or more dissents according to the person. How Chief Justice John Roberts will ultimately vote and whether he will join an already written opinion or draft his own is unclear. The document labeled as a first draft of the majority opinion includes a notation that it was circulated among the justices on February 10th. If the Alito draft is adopted, it would rule in favor of Mississippi in the closely watched case over that state's attempt to ban most abortions after 15 weeks of pregnancy. Therefore, Josh Gerstein announces and concedes that he had extensive discussions with the source of the document, and he was not merely a passive recipient of a document alone. Writing about his own actions and publication, Josh Gerstein further reported and commented in a follow-up news article, the disclosure of a draft opinion in a Supreme Court case is a highly unusual occurrence. Supreme Court historian, former law clerks, and other watchers say they cannot recall a previous instance before Monday's publication of a draft opinion in the Mississippi abortion rights case. I want to bring you guys to an article, another one written by Josh Gerstein himself. And it looks like they took it down. That's interesting because I just brought it up just a couple hours ago. So we'll figure out what happened there. So let's go back to the indictment. Josh Gerstein further admitted that the purpose of the stolen document being published was to influence the outcome of the U.S. Supreme Court's final decision in the case. A Wall Street Journal editorial Wednesday noted alarm about the potential ruling on the left and expressed concern that Roberts might be trying to turn one or both of the court's newest justices, Barrett and Kavanaugh, to join an opinion that would uphold the Mississippi law without completely abandoning Roe. The journal editorial led at least one prolific conservative court watcher to suspect some sort of leak from the court. Still, much of what's known about the inner workings of the court has been driven by leaks or perceived leaks from Supreme Court law clerks, the roughly 36 attorneys who typically do 1-year stints reading briefs and helping draft opinions. At the start of a television interview by Josh Gerstein on the television network MSNBC with Rachel Maddow, he discusses his and his editor's high degree of confidence in the source of the leaked information and document, indicating his extensive conversations with the source. This is not a case where a reporter simply received a document out of the blue. Illustrating Josh Gerstein's motivations and professional benefit from these actions, he appeared as a guest on Meet the Press on May 8th, 2022, to discuss on national television, watched by most of the political class of the country, these developments. Further indicating Josh Gerstein's motives that stealing and publishing the draft opinion would benefit his partisan political preferences in the upcoming November elections, he stated on Meet the Press, Chuck Todd said, "You know what? you know what he hasn't done, Josh, to keep it sort of in your wheelhouse? He hasn't really commented on the leaked document. You would think he'd say, look at what my judges did. I told you they would overturn Roe. And now maybe he's waiting to make sure it actually happens. But the lack of taking credit, his political antenna to me is telling him he's a little nervous. Gerstein replied, yeah, you do wonder if he's seeing some of this polling that clearly other Republicans are seeing, saying that this issue may be a loser for them in the fall. And I also wonder in some of these races where Trump's nomination or his endorsements has made the difference, whether when you get to the general election, you're going to see candidates try to straddle, sort of like Glenn Youngkin did, right? Where he was sort of semi-accepting Trump's energy, but didn't quite want to appear with him. Can they maintain that straddle all the way to November? In another point in Meet the Press program, Josh Gerstein underscores his awareness of the dangers of his action and the situation he created. Chuck Todd went on to say, Josh, let me start with you. Has it sunk in what your report perhaps has done to the Supreme Court for a generation? Gerstein replied, well, it's starting to. I mean, when the large black imposing fence went up around the court earlier in the week, it certainly indicated that the court itself now realizes that whatever decision it issues on, this is going to have pretty dramatic, momentous implications, and probably is likely to anger a number of people on one side or the other. Moving on with the indictment, Josh Gerstein has decades of journalistic, legal, and political experience sufficient to inform him both of how to enter into a conspiracy and engage in concerted action to illegally obtain the draft U.S. Supreme Court opinion, and of the illegality of conspiring in the theft of the government document. Politico publishes on its website, along with news articles, news analysis, and opinion columns published by its authors, profile information about those authors. See the website page. Gerstein's profile page states, just before President Obama's inauguration in 2009, Gerstein joined Politico as a White House reporter, returning to a beat he covered as a White House correspondent for ABC News. At ABC, he reported on Bill Clinton's impeachment and President George W. Bush's response to the terrorist attacks of September 11, 2001. Moreover, he's already an expert on the Freedom of Information Act and has pursued several such cases seeking details about alleged abuse of detainees at Guantanamo and the government's handling of leaks of classified information. And Gerstein covers the intersection of law and politics, including Special Counsel Robert Mueller's investigation of President Donald Trump and his associates, as well as ensuing counter investigations into the origins of the FBI's initial inquiry into the Trump-Russia saga. While not a lawyer, Gerstein spent more time in courtrooms and more time reading legal pleadings than many members of the bar. For more than a decade, he has taken Politico readers inside the most celebrated political trials of our era, involving figures like former Senator John Edwards, former White House counsel Greg Craig, longtime Trump confidant Roger Stone, and former Trump campaign manager Paul Manafort. Gerstein served as a contributor to MSNBC for several of those trials. In addition, his reporting and legal analysis has been featured in outlets such as National Public Radio, CNN, Fox News, Al Jazeera, the New York Times, and the New Republic. Gerstein also reports on the Justice Department and legal controversies, including Supreme Court showdowns over same-sex marriage and Obamacare. All of the recent Supreme Court nominations, criminal justice reform, and battles over executive privilege. Moreover, Gerstein began his journalism career in 1991 when he joined CNN's Special Assignment Unit as a researcher and associate producer, according to his LinkedIn page. He stayed with CNN for about 3 years and then joined ABC as an investigative reporter and producer in 1995, his profile says. The majority of his career was spent in Washington, D.C. Gerstein held several positions with ABC, where he worked for about 8 years, his profile says. He covered Senator Bob Dole's presidential campaign from start to finish as a presidential campaign reporter, he wrote on his LinkedIn page. He then took on a role as a White House reporter for about 2 years, followed by another 2 years as a White House correspondent. He worked in Beijing for about 1.5 years as a correspondent for ABC. His political profile says that as a Beijing correspondent, he was reporting from the deserted streets of China's capital during the SARS crisis on threats to U.S. diplomats in Pakistan and from Afghanistan on the families of Guantanamo prisoners. He then spent almost 5 years working for the New York Sun based in the San Francisco Bay Area. From 2003 to 2008, Gerstein was based in Northern California as a reporter for the New York Sun, covering such stories as Arnold Schwarzenegger's unannounced gubernatorial bid and the ins and outs of 2 presidential elections, his political profile says. Moreover, in 2003, when he married, he was the Beijing correspondent for ABC News. From 1995 to 2000, his wife, June C, was a speechwriter for President Bill Clinton and Hillary Rodham Clinton, and later was the chief speechwriter for Mrs. Clinton's senatorial campaign. Furthermore, also indicating the political motivations and Josh Gerstein's knowledge of both the wrongfulness and dangerousness of his actions, his wife's longtime political, legal, and international knowledge and connections would inform his understanding and his motivations. Today, Sheikh is the director of university communications for NYU Shanghai, according to her NYU profile. Her personal website describes her as a speechwriter, policy consultant, and journalist. June Sheikh is a writer and lawyer with more than 20 years experience in public policy, communications, and speechwriting, her website says. In 1994, she began her career as a cops and courts reporter for a Florida newspaper, but left after a year to assist then First Lady Hillary Rodham Clinton with her syndicated newspaper column and speeches. Going into count 1 of the causes of action, count 1 is receiving government property and secrets. The previous allegations of the entirety of this indictment are repeated and realleged as incorporated herein with the same force and effect as if fully set forth herein. A journalist, like any other citizen, may not participate in the theft of or the stolen documents or information, whether classified or private or trade secrets or the like, including journalists, may not entice, encourage, arrange, or conspire in theft of documents or information. The U.S. Supreme Court treats drafts of legal decisions as among confidential information and documents, including as pre-decisional governmental documents protected by the governmental deliberative process privilege under the laws similar to trade secrets and proprietary information. Judicial clerks who assist U.S. Supreme Court justices must sign contracts and pledges of confidentiality that include the confidentiality of such drafts, among many other confidential information. 18 U.S.C. 641 criminalizes this conduct. Whoever embezzles, steals, purloins, or knowingly converts to his use or the use of another or without authority sells, conveys, or disposes of any record, voucher, money, or any or thing of value of the United States or of any department or agency thereof, or any property made or being made under contract for the United States or any department or agency thereof, or whoever receives, conceals, or retains the same with intent to convert it to his use or gain, knowing it to have been embezzled, stolen, purloined, or converted, shall be fined under this title or imprisoned not more than 10 years or both. But if the value of such property in the aggregate, combining amounts from all the counts for which the defendant is convicted in a single case, does not exceed the sum of $1,000, he shall be fined under this title and imprisoned not more than 1 year or both. The word value means face, par, or market value, or cost price, either wholesale or retail, whichever is greater. The U.S. Court of Appeals for the District of Columbia Circuit has held that information can be a thing under value, or a thing of value under 18 U.S.C. 641, see United States versus Collins 56 F3D. Let's move down. In the United States versus DiGilio, defendants were convicted of violating the statute for photocopying documents in an FBI file. They appealed the conviction, arguing that because they only removed copies of the documents and never deprived the FBI of their use, they did not break the law. The Federal Court of Appeals for the Third Circuit upheld the conviction, holding that a duplicate copy is a record for the purposes of a statute, and duplicating copies belonging to the government were stolen. 18 U.S. Code 207 requires that whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so, or with intent to do so, takes and carries away any record, proceeding, map, book, paper, document, or other thing filed or deposited with any clerk or officer of any court of the United States, or in any public office, or with any judicial or public officer of the United States, shall be fined under this title or imprisoned not more than 3 years, or both. Whoever having the custody of any such record, proceeding, map, book, document, paper, or thing willfully and unlawfully conceals, removes, mutilates, obliterates, falsifies, or destroys, the same shall be fined under this title or imprisoned not more than 3 years, or both, and shall forfeit his office and be disqualified from holding any office under the United States. As used in this subsection, the term office does not include the office held by a person as a retired officer of the armed forces of the United States. 18 U.S.C. 2315 also criminalizes the knowing receipt of stolen goods. Whoever receives, possesses, conceals, stores, barters, sells, or disposes of any goods, wares, or merchandise, securities, or money of the value of $5,000 or more, or pledges or accepts a security for a loan, any goods, wares, or merchandise, or securities of the value of $500 or more, which have crossed a state or United States boundary after being stolen, unlawfully converted, or taken, knowing the same to have been stolen, unlawfully converted, or taken, or whoever receives, possesses, conceals, stores, barters, sells, or disposes of any falsely made, forged, altered, or counterfeited securities or tax stamps, or pledges or accepts as security for a loan any falsely made, forged, altered, or counterfeited securities or tax stamps, moving as, or which are part of, or which constitute interstate or foreign commerce, knowing the same to have been so falsely made, forged, altered, or counterfeited, or whoever receives in interstate or foreign commerce, or conceals, stores, barters, sells, or disposes of any tool, implement, or thing used to or intended to be used in falsely making, forging, altering, or counterfeiting any security or tax stamp, or any part thereof, moving as, or which is part of, or which constitutes interstate or foreign commerce, knowing that the same is fitted to be used or has been used in falsely making, forging, altering, or counterfeiting any security or tax stamp, or any part thereof, or whoever receives, possesses, conceals, stores, barters, sells, or disposes of any veteran's memorial object which has crossed a state or United States boundary after being stolen lawfully, unlawfully, converted, or taken, knowing the same to have been stolen, unlawfully converted, or taken, shall be fined under this title or imprisoned not more than 10 years or both, If the offense involves a pre-retail medical product as defined in section 670, the punishment for the offense shall be the same as the punishment for an offense under section 670, unless the punishment under the section is greater. If the offense involves the receipt, possession, concealment, storage, barter, sale, or disposal of veterans memorial objects with a value in the aggregate of less than $1,000, the defendant shall be fined under this title or imprisoned not more than 1 year or both. This section shall not apply to any falsely made, forged, altered, counterfeited, or spurious representation of an obligation or other security of the United States, or of an obligation, bond, security, certificate, security, treasury note, bill, promise to pay, or banknote issued by any foreign government. This section also shall not apply to any falsely made, forged, altered, counterfeited, or spurious representation of any banknote or bill issued by a bank or corporation of any foreign country which is intended by the laws or usage of such country to circulate as money. For purposes of this section, the term state includes a state of the United States, the District of Columbia, and any Commonwealth territory or possession of the United States. For purposes of this section, the term Veterans Memorial Object means a grave marker, headstone, monument, or other object intended to permanently honor a veteran or mark a veteran's grave, or any monument that signifies an event of national, military, historical significance. Moving on to count two. Count two is conspiracy to steal government property and secrets. The previous allegations of the entirety of this indictment are repeated and realleged as incorporated herein with the same force and effect as if fully set forth herein. 18 U.S.C. 371 criminalizes this conduct. If two or more persons conspire either to commit any offense against the United States or to defraud the United States or any agency thereof in any manner for any purpose, and one or more of such persons do not act to affect the object of the conspiracy, each shall be fined under this title or imprisoned not more than 5 years or both. If, however, the offense, the commission of which is the object of the conspiracy, is a misdemeanor only, the punishment for such conspiracy shall not exceed the maximum punishment provided for such misdemeanor. Whenever we do present this indictment, it will finally read, we, the citizens grand jury, find probable cause that putative defendant Josh Gerstein has committed all of the crimes as set forth herein.
So I want to thank the grand jurors for their attention. We'll be in contact with you further. We will present a clean indictment to you. We will ask you to appoint a foreperson to sign the indictment on your behalf if you decide to indict. The standard for probable cause will be read to you later, but it is a very, very low standard. And Gerstein will have a right to a full defense in a citizen's trial, which will take place if we get the indictment, and I'm confident we will, between June 13th and the rest of that week. Thank you for tuning in. Thank you for listening to us. This is a serious matter, and we will address it in that fashion. God bless you all.